We winged our way back in the middle of the night last night.
Okay. That was the move. Yeah.
So that we could be back for all of our broadcast and print commitments today. And we did. And I just want to thank our staff for helping so much with us yesterday, because we're literally flying blind at the convention without a whole lot of stuff in front of it. I mean, technology now at least allowed us. I was able to watch local television in Chicago from Charlotte through my iPad. But other than that, it was really hard to do. So these guys did an amazing job.
Great work. Thanks, everyone.
Job to do that. All right. Well, let's get right into this, because James Glasgow is on the Super Celebrity Hotline, and he of course is the state's attorney of Will County, and then the lead prosecutor. Which, Jim, you and I talked about this a little bit. That it's a pretty risky thing to be the elected official, also lead chair in probably the biggest heater case your county has seen in a long, long, long time. You've had a lot of big cases. You got one going on still right now, but to be the lead chair in this, and then the first couple of days it appeared, and again, this is pundits. You talked about them a little bit yesterday. This is also media types that are watching the defense push you back, and get the judge to go along with them to some degree. In that first week, Jim, were you worried about how this case was going?
Well, obviously it was a little unsettling, but I think some of those issues got blown out of proportion. I don't want to go into that in any depth, but the case picked up speed as we moved along, and we never lost our focus. And as far as being lead counsel, this was my case from the birth. I was the one that decided to proceed with the exhumation, and when I did that, everybody said I was crazy. So when I wrote the law, they said I was crazy. So I've endured a lot of slings and arrows through this whole process, and what I thought was hilarious is when the Supreme Court said I was on beam, all of a sudden everybody says, "Oh, maybe he isn't crazy."
Well, and we're going to get to that in a second, because I think there's been a lot of misunderstanding. The last couple of days, you explained it, I think, very, very well in your press conference yesterday, and we've had a lot of people call in and having concerns about it. So let's jump into that for a second. The hearsay law is not as simple as, well, now anybody can just say anything about anybody and go to court and get a conviction on somebody they don't like because they heard some conversation, right?
Correct. There's a very, first of all, you have to prove by a preponderance of the evidence that you willfully diverted the witness. Under the law that I had written, that diversion had to be murder. So I mean, it was the ultimate diversion. And let me go back. Let's take that out of legalese for a second. So what basically the law that you guys drafted, and there are some other laws around the country that are similar to this, but the law that you drafted specifically says that if you kill somebody to silence them because they were going to testify against you for another crime, that hearsay evidence surrounding that individual who's now dead can be entered into court. But before you do that, a judge has to sign off on this. A judge has to sign off based on this preponderance of evidence in kind of a mini trial in advance. Yes. And these statements have to be relevant and probative to the issue at hand. They're not just any statement, bro.
Yeah.
Like if someone is murdered in a bathroom and it's made to look like an accident, and they happen to have been told by the murderer, I could kill you and make it look like an accident, that's pretty relevant and pretty probative.
Jim, what about the criticism that, I mean, and I agree, it as Rose said, it's been widely, I think, misunderstood and sometimes misreported, but some of the defense attorneys were saying yesterday that it's so specific that it was written for one case.
Those guys don't tell the truth about anything now, do they? In Giles versus California, which was recently decided by the Supreme Court, I think a couple years ago, and I actually flew out and watched the argument, Anton Scalia, who's a very conservative justice and who is a champion of cross-examination and confrontation, found that 400 years ago the concept of forfeiture by wrongdoing was in place in the common law. It was there when the drafters of the Constitution wrote the Constitution, and that's one of his tests to determine whether or not he's going to go along with something that in the common law. But anyway, The federal government in 1997 enacted a law. It was Section 804B, which we have now adopted in Illinois as of January 1st, 2011, which is basically forfeiture by wrongdoing, and it's an equitable forfeiture. If you deliberately basically destroy evidence by getting this witness out of the way, you can't come in, thumb your nose at the judge, and laugh and say, "Ha-ha, you can't get me now." That's basically the concept.
And the idea here, and again, they were very specific about saying, this Drew's Law, and a lot of people called it that, but that was not what the legislature called it. But they called it that because they thought that they believed that they could try to create some firestorm, lever out some firestorm against you by saying, this is unconstitutional, and using some of the modern political environment to try to suppress the use of this because it's government overreach, and look at what they're doing, and they're going to use hearsay and all of that. When in reality, it actually is protecting the rights of that person who just got murdered to be able to testify. But even beyond that, it's not going to be used in cases like this. This is the sort of thing that actually would be used and is similarly used in RICO cases against gangs and criminal enterprises.
Well, the one thing that has to be understood, there were other murder cases that in other counties where they used so-called Drew's Law before I did. In fact, I know of a case specifically in DuPage County where they used it. And when we did the hearing initially in front of Judge White, where he found by a preponderance of the evidence that Drew Peterson murdered Stacy Peterson and murdered Kathleen Peterson to silence them, then the Hansen case came down, and we took it up on appeal because Judge White had suppressed some statements that Hansen said should come in. We won that appeal. And in the meantime, the Supreme Court on January 1st, 2011, adopted Rule 804B, which made my statute irrelevant. I don't know if everybody understands that. When we proceeded to trial, it wasn't my statute that governed. It was the new rules of the Supreme Court. So,
and that's why you have, and then I want to get to that in just a second here. We got to stop for 45 seconds of traffic. But
sure.
On the other side, I want to talk about the risk, how you feel about this conviction standing, because obviously, and there were a lot of emotions at those press conferences yesterday. The defense lawyers, very emotional. You had a moment, James Glasgow, that was pretty emotional. I want to talk about that. And then the jury just spoke, and we'll talk a little bit about what they saw you do that they bought into, what the turning point moment for them. But stay right here. James Glasgow, Will County State's Attorney, is with us. His first long-form interview right here, and thank you for holding up your commitment to us to do that. So hold on one second. We'll come right back to you. But first, Christina's got traffic weather first on the 5s. All right. James Glasgow, we're talking to from the Will County State's Attorney. He is the Will County State's Attorney who's lead chair in Drew Peterson. Okay. The jury just got up and said that in a press conference that the turning point moment for them was the fact that Kathleen Savio had been brutalized. Your forensic scientist that you put up on the stand that said this was not just a simple slip and fall, because she couldn't possibly had, including Michael Bodden, who we talked to yesterday, couldn't possibly have had the series of wounds that she had if simply she had just slipped. Was that the thing that you knew going into this was going to be the clarifying moment for them? I'm sorry, Jim. Go ahead. I'm sorry. Go ahead.
Yeah, we spend great pains to make sure that our experts would outduel theirs. And I started my rebuttal argument trying to show the ridiculousness of their positions on a number of the critical injuries, one of them being the abrasion on her buttocks. Dr. Mitchell at the original autopsy clearly described it as an abrasion, and it was about 3 inches by 1 inch. Well, that abrasion couldn't have been gotten except on a rough surface, and they were creating this scenario of a slip and fall in the tub. So what Dr. Jensen and Dr. DeMaio did is just say, well, that really isn't there. That's an artifact. And Dr. Bodden did a wonderful job explaining to the jury what an artifact is. There was some dried blood on her back that to a layperson might look like an injury. He pointed to it and said, that's dried blood that occurred after death. That's an artifact. So there was no question that this was a serious abrasion. And who gets into a hot tub with a raw abrasion on their buttocks? Yeah. Those are raw nerve endings. That doesn't happen. And we went to great pains of showing that the injury to her head was a small laceration, only about 1 inch long, and it only broke the skin and went no further, that the force terminated at the skin. Well, how can you slam your head into a tub and have the force terminate at the skin? It's impossible.
So why was this swept under the rug in the first place?
Well, there was a lot of inexperience and some indifference that combined for the perfect storm. And, right now, that went before a coroner's inquest jury. That was the biggest problem, because those are lay people that come in. They weren't given very detailed information, and they were also given some misinformation. And so they came up with the wrong verdict of accident. Now what's done under the new law in Illinois is the coroner confers with the forensic pathologist, the board-certified forensic pathologist, who is the same as a medical examiner, and he basically makes the call on the manner of death, just like Dr. Bloom did and Dr. Case did. And I want to point out, Dr. Bloom did an excellent job. He did a second autopsy, and he was able to determine she had no bruising on her back, the backs of her arms, and her buttocks. Now, how do you fall backwards and and get no injuries whatsoever there? That doesn't happen. He also found that the bruises on her front hip, there were 3 of them, and they were very deep, which meant there was a significant force that had to be applied. And Dr. Baden, who did some research back when he was at Bellevue Hospital on heart conditions related to the diaphragm, found a bruise on the right diaphragm consistent with a bear hug. So if you're talking about drowning someone in a toilet, you got the 2 clavicle injuries, which line up perfectly with the toilet bowl, and you've got the bear hug, and you got the abrasion, all of which could have occurred if you bent somebody over a toilet to drown them.
So that's the theory that he drowned her in a toilet.
We didn't present that specific scenario, and I'm not saying that that's the absolute, because I didn't have to prove how. And the jury was smart. They knew that there was a sink that you could drown someone in. They knew there was a toilet and a tub. And I just saw a brief snippet of what one of the jurors said. Dr. Bloom described the dried blood on her face. Well, that dried blood came from a wound that would have stopped dripping blood out about 5 minutes after her death. So her face couldn't have been in water.
Jim, you can hear the passion in your voice even now as you lay out the case, and justice has been served. And yesterday you finally had the chance to let out a little bit of personal feelings and emotion. You talked about Drew Peterson and your thoughts on him. Can you talk about how hard it was to see the defense team wearing their sunglasses and embracing the media, and Drew kind of thinking strutting around thinking he owned the world, and what a relief it was for you, and why you did decide to kind of let your heart out a little bit yesterday and tell us how you personally felt about Drew and the defense team?
Well, I actually think the defense team helps us. Their creepy, disrespectful behavior at every press conference just galvanized the public against them. Not that the public had any control over the jury. And I think the jury was very, ethical in maintaining their integrity and not watching the news coverage. So I don't think they were affected by them. But when they did that Three Stooges routine about Stacy, where's Stacy? Who's Stacy? Where'd you go? Ooh, that kind of nonsense. Mm-hmm. And then Jeff Ruby, the restaurateur, took out the ad in the Sun-Times and the Herald News and said, "This is pathetic. We're talking about the death of 2 women here, and they're mocking it." And that needed to be said. And I can't tell you. I just did an interview with Mike Puccinelli, and 3 people stopped to shake my hand and thank me while we were standing there. And I went to lunch, and just nearly everybody in the restaurant came over to the table. And it's not like this is rock star BS. This is a genuine outpouring of happiness and thankfulness that this monster got convicted after spewing his vitriolic misogyny on national and worldwide television, mocking the death of these 2 women. There was a real backlash from the moral, I don't want to call it the moral majority, but people that understand, common decency, compassion, and empathy, and they are just ecstatic with his conviction.
Jim, was this personal for you then?
Personal from the standpoint is it's my job to protect the public, and this guy was like a sore on justice. I mean, he had to be removed, and I think we've done that now.
And you're confident this will hold up?
Yes, absolutely. As I said, there's case law at the federal level since 1997, all affirming this concept. Giles versus California is a recent Supreme Court case where Justice Scalia, who's one of the most conservative justices, affirmed the equitable forfeiture. You forfeit your right to confront the witness when you do this. So we're confident, and Judge Bermilla really cut us to the bone on the evidence that came in.
Yeah.
We didn't get any gifts, that's for sure.
No, but you did. But well, you got one from the defense.
We did
when they put the divorce lawyer up.
We did.
You did, and that's. Do you think that was a big turning point too? Was that a mistake on their part?
Well, again, it's a tactical decision, and they reaffirmed why they did it. They calculatedly felt they could destroy her credibility. But the reverse analysis is, if she's saying that she knows how he killed her, if he really didn't kill her, where's the leverage?
Yeah. Well, congratulations to you, Jim. James Glasgow, who is the Will County State's Attorney. The difference here is a dead-eyed professional who goes in and again, and even for people like myself who always thought that Drew Peterson was a creepy guy who did all of these things, I was concerned about the first couple weeks of this. But you guys came through, and there was just a little bit of providence in there, but it was excellent lawyering on your part. So congratulations.
Thank you. And if you get a chance, the same thing happened in the Stacey Peterson case out in California. They almost had a mistrial at the beginning of that, and it looked like the prosecution was stumbling. And they picked themselves up and just sprinted across the finish line. So, and in that case, they could not prove how she was killed either because her body was so badly decomposed. And the jury, when they were interviewed, it didn't matter to them how. They just knew that he did it based on the evidence.
All right, Jim. Thanks very much. Appreciate your time.
All right, thank you. Take care, guys.
James Glasgow, Will County State's Attorney.